You know, most divorce stories start with a fight. This one? This one starts with a hug. We're about to dive into a legal case that began as a model for how to do divorce right, but it quickly spiraled into a decade-long battle across state lines. And the wildest part? It all hinges on what happened over just 2 pivotal days.
I mean, just listen to this quote from the petitioner. He said, "We were the poster parents for what a shared custody agreement is." That's a pretty powerful statement, right? And back in 2015, Brooke and Gerald Hirschfeld really did seem to have it all figured out. They crafted this plan that was so cooperative, so focused on their children, it really was the perfect blueprint for a post-divorced family. But as we're about to see, even the most perfect blueprints can be torn to shreds.
So, to really understand how it all fell apart so spectacularly, we first have to look at how perfectly it was all put together. This story really starts with their separation agreement from back in March of 2015.
And look, this wasn't your typical dry legal document. Not at all. This was more like a mission statement for their new lives. They agreed on shared physical care because they both believed the kids needed frequent contact with both of them. They agreed to make all the big decisions, we're talking school, healthcare, religion, together. They even had a plan for the future, committing to use mediation if they ever disagreed. This whole thing was built on a foundation of mutual respect.
The financial side of things was just as balanced. Both of them mutually waived any right to spousal support. So Gerald wouldn't get it, Brooke wouldn't get it. It was a completely clean slate. Neither one had a future financial claim on the other. It really signaled a true fresh start for everyone.
So as you're looking through this, you're probably thinking, wow, they thought of everything. But as we dig into the document, one tiny detail stands out. In the section that identifies the kids, the little boxes for their social security numbers, they were just left blank. Now you might think, so what, a minor oversight. But trust me on this one, that seemingly small detail is going to become incredibly important down the road.
Now, an agreement this good isn't just based on trust. It's actually backed up by some pretty powerful legal guardrails. We're talking federal laws designed to prevent the exact kind of multi-state chaos that can absolutely wreck a co-parenting plan.
At the very heart of this is a federal law called UIFSA. Think of it as the ultimate rulebook for child support and custody across state lines. Its core principle is simple: one order, one state. What that means is only one court in one state gets to be the referee for the entire game, no matter where the parents might move. This power has a name: Continuing Exclusive Jurisdiction, or CEJ for short. And it exists to prevent confusion and stop different states from making conflicting orders.
And in this case, the law was crystal clear. Since Gerald, the petitioner, stayed in Colorado, and only Colorado, had that continuing exclusive jurisdiction. Period. Any changes, any enforcement, any official action at all had to go through the Colorado courts. That wasn't just a suggestion, that was the law. So they had the perfect agreement, and they had this powerful legal framework to protect it. That brings us to June 9th, 2015, the day this whole ideal plan was officially sealed by the court. I mean, just look at this timeline. It really shows the peak of their cooperation. They didn't show up in separate cars with an army of lawyers. No, they drove to the courthouse together. Their agreement was quickly approved by the judge, making it official. And when it was all over, they walked out and shared a hug. It was the perfect, amicable end.
And in that moment, it was done. The court made their agreement an official order. They had actually done it. They achieved what so many families hope for, but so few manage: a peaceful, fair, and legally solid resolution that put their kids first. A perfect ending to their marriage, and what seemed like the perfect start to their new chapter as co-parents.
But that perfect ending, it lasted less than 24 hours.
The very next day, on June 10th, 2015, the entire foundation of their cooperative, Colorado-based agreement was completely shattered.
Without getting the court's approval, and in direct violation of the order that was signed just hours earlier, the respondent, Brooke, relocated with the children to South Dakota. Now remember, the state with exclusive jurisdiction was Colorado, but now the children were in a different state. This one single act triggered a decade of legal conflict that is still going on today.
So the big question is, how? How could a model divorce, one that was called a poster for shared custody and was protected by federal law, just collapse overnight? How did one state's crystal clear jurisdiction get so tangled up with another's, and what happened to that perfect plan? Well, that's where this story gets really complicated. We'll tell you what happened next in part 2.